It's been submitted under Section 36 of the Electricity Act, and in Section 36 cases, it's Scottish ministers that ultimately decide whether or not to approve the application after consideration of my report. So I can confirm that I will be taking a full note of the meeting today. So if there are any issues with connectivity and you miss something, you should be able to follow along the discussion in the note. If necessary, we can follow up any points in correspondence as to the meeting. I did want to take this moment just to apologise briefly about any confusion with the note of the previous meeting. Unfortunately, there was an automatically generated letter, as I understand it, that was issued with my note of the meeting. And it really didn't, having reviewed it, it really didn't make total sense, seen as though we paused proceedings at that point. In particular, the instructions for parties to opt in to topic areas, because obviously we hadn't discussed those topic areas and the preferred types of procedures. So don't worry to everybody. We will get round to that today, and everybody will be given the opportunity to opt into their desired topic areas. So this meeting concerns the arrangements for the inquiry and the associated proceedings necessary to consider the case. It doesn't form part of the inquiry itself. Therefore, we're not going to take any evidence on the merits of the proposal today. The agenda was circulated last week following my receipt of the applicant's updated position statement. Thanks for getting that to me on time. So parties will have had opportunity to consider my current thinking, which has changed slightly from my previous agenda, as people will see. Sorry, we've just got somebody else coming in. Mr. Douglas, just confirm you can hear and see me okay? See what happens with that. Okay, so apologies for that. So as I say, my thinking has changed slightly on one or two issues, and that's because given this brief recess in proceedings, I've had a chance to read around some of the topic areas and look at some of the areas and give a more detailed focus on those. So hopefully we'll be able to progress quickly through various points of the agenda, pausing only to debate any areas of disagreement. But first, I have a little bit of housekeeping. So the meeting is being recorded and broadcast live. A member of our IT team is going to remain online in case of any technical difficulties. In due course, the recording will be available to view on the internet. I believe that's on YouTube nowadays. In accepting the invitation to the meeting, you've agreed to being recorded. Can I just offer the opportunity to any parties not comfortable with being recorded to either leave the meeting, you can follow along through the link that was sent to you, or else you're able to turn off your camera if you'd prefer to do that. You might find it useful to use the grid view. You'll see at the top there are different things about the view. The grid view allows you to see everybody at once, or you might prefer to have it focused on a particular speaker. As I said earlier, please do leave your microphone on mute. Whilst we're going through the meeting, if you wave, I should be able to catch you, and I'll come to you at the first opportunity. There is a raise hand function you'll see around about the top centre. If you've got the same setup as me, it says raise and has a picture of a hand. If you just press that once, I'll know that you want to speak and I'll come to you. And finally, even though this is a virtual meeting, it's still important to make sure mobile phones are switched to silent if possible. Thank you. I've not planned a formal break in today's meeting, but I will review this at around about 2:30, just to check whether parties feel a short pause will be welcome. I may also call a brief recess if I need to retire to consider something in detail before moving on to the next item in the agenda. Does all of that make sense? Yeah. Okay, thank you. So in terms of introductions, I'm going to now invite parties to introduce themselves. I have done the best I could based upon the attendees from the previous meeting. I've populated a potential list in the agenda, as you'll see. So hopefully that's right. If not, I can modify that as we go through it today. I'm going to work down in order. So I'm going to start with the applicant for Muirhall Energy Limited. Thank you.
Thank you, sir. Good afternoon. My name is Marcus Trinnick. I'm a solicitor of King's Counsel, instructed by Neil Collar, a partner in Brodie's. And also with me in the room, Sarah McIntosh, Managing Director of Muirhall Energy Limited, Amanda Swan, Director of Development for the company, Tamika Dawson, a Senior Consenting Manager for the company, and Susan Bell, Senior Development Manager. Thank you, sir.
Thank you very much. And the council?
Good afternoon, sir. My name is Ron Kirk. I'm a solicitor at Scottish Borders Council. I'm covering this meeting today for my colleague Sarah Thompson, who will be principally taking this matter forward thereafter.
Okay, thank you very much. And we've got 3 community councils that have indicated a desire to participate. If we can just go through those in the order that's on the agenda, that would be great, please. Upper Teviot, Dale and Borthwick Water first.
That's Walter.
Oh, right, that's Walter. Is Walter with us? Have you managed to join us?
Yeah. Thank you. A few technical problems.
All right, no problem. Thank you very much. So it's Walter Douglas. Yeah, you were here last time. Thanks, Walter. And is it Dr. Cole for
It's Jeffrey Colby for Upper Liddesdale and Hermitage Community Council.
Thank you very much. And South Dean?
Philip Kerr, Chair of South Dean Community Council. Thank you.
Thank you very much. And then we have the representatives of the Defence Infrastructure Organisation.
Good afternoon, sir. My name is Ruth Crawford, King's Counsel. I'm instructed by Morton Fraser McRoberts and by Mr. Milne, who's sitting to my right this afternoon. Online, I'm also accompanied by Mr. Egan and Mr. Hopton for the Defence Infrastructure Organisation. Thank you.
That's great. Thank you very much. And for NATS Safeguarding?
Good afternoon, Alistair Auld, Radar Engineer representing NATS Safeguarding. I will have to drop off the call at 2, but I provided a statement on Friday you should have available.
I do. Thank you very much for that. Teviot Landscape Conservation.
Good afternoon, sir. I'm Dr. Christopher Ford, representing Teviot Landscape Conservation Group.
Thank you very much. So I'll now also work through the list of other interested parties. I do have some apologies that have already been sent through, and I've had some notices of topic areas that people would like to be involved in advance. That'll be included within the note of the meeting, but I'll just briefly go through these. So we have Borderlands Museum. Mr. Moffat, are you with us again today?
That's myself, yes. Hello. Yes, I'm Kenneth Moffat, the Borderlands Museum and business owner at Teviot Head.
Okay, thank you. And then Caroline Gray. Elizabeth Litt. No. As I say, there are some apologies, so I've not noted these on my agenda. Helen Chatterton. Jane Bauer.
Hello, I'm a landowner, farmer with land bordering the Teviot site.
Thank you very much. Mr. Dawson, John Dawson. Marion Livingston. Oh, is that Jane? Yeah, we've got Jane there. So right, you've just come up on my screen. Mark Chatterton. Mr. Luckin, I have apologies for. Mr. Powell, James Powell. Gillian Cooper. Tom Turner. Crimson Turner. Claire Novica Price, I have apologies for. Pete Lamb. Frank Booth. Colin Hope. And Duncan Taylor. Okay, maybe some of these parties are following along on the live stream. So are there any preliminary questions or issues to raise at this stage before we get underway with the agenda proper? No? Okay, perfect. So item 3 on the agenda is the code of practice for handling inquiries and flexibility for proceedings. So there are no detailed procedural rules for conduct of inquiries under the Electricity Act. However, as parties will know, DPEA has produced a code of practice modelled on the 2013 Planning Appeals Regulations, and I intend to apply the code of practice in this case. If you haven't seen it, the document's available on the DPEA website. It was also a link was included on the agenda, and I will include a link to it in my note of the meeting. I should point out at this point, I suppose, there may be some confusion amongst some parties that we're shortly going to be retiring the current code of practice and introducing a new procedure to better reflect the updated legislative framework for dealing with cases through the Act. So as you'll know, in the emerging framework, inquiries wouldn't be automatically be triggered by a council objection, as is currently the case. In future, a report-led examination will take place, and the details of how these will operate will be included in a new procedure that's likely to be published during the course of this inquiry. However, because this case, the council's objection was made before the 18th of February this year, can confirm this inquiry will proceed using the old system and the existing code of conduct. Essentially, code of practice. Essentially, this code allows for flexible procedures. So each issue will be dealt with by the most appropriate mode of examination. This could be an inquiry session, a hearing, or further written submissions. With many of the issues in this case, I'm satisfied that sufficient information has already been submitted, and I envisage that no further procedures required. This doesn't mean that I believe those issues are unimportant. It just means that I have enough information on these matters. When I write my report to the ministers, I'll take into account all the environmental information submitted by the applicant, together with all consultation responses and letters of representation already lodged with the Energy Consents Unit. I'd like to highlight, especially for parties following along at home, who might not be familiar with the inquiry process, that the type of procedure that's followed, or the absence of any further procedure, therefore, isn't an indication of the importance of a particular issue. I also want to take the opportunity at this stage to explain briefly the differences between a hearing and an inquiry session for those following along that haven't been involved in anything like this before, because there's likely going to be a little bit of a discussion on this later today. So hearing sessions take the form of a structured discussion between the parties involved, which I would lead. There'd be no formal leading of evidence or cross-examination. I'd prepare an agenda for each of the hearing sessions in advance. Everyone who's advised me that they want to take part can participate in a particular hearing session. There's no need for legal representation, although parties' lawyers can and often do take part in the discussions. Hearings are generally more informal than inquiry sessions and are particularly suited to topics where there's a difference of opinion on less technical issues. For inquiry sessions, each party is invited to present evidence in turn. This would be subject to cross-examination by those with an opposing view. Usually parties are legally represented and lawyers would undertake this cross-examination or the questioning of witnesses, although it's not essential to have a lawyer. I'll also have questions, of course. Inquiry sessions are more formal than hearing sessions and are particularly suited to those topics where there's a lot of technical evidence to be given. The evidence is presented by expert witnesses in the specific topic areas in order to articulate the position of the parties. So you'll see in the agenda and its annexes that I've set out my preliminary views on how the case should proceed. However, the keen-eyed, as I said earlier, will notice that I've modified my thinking in a couple of places, and we'll discuss this as we work through the agenda today. Site visits are another important part of my evidence gathering to ensure I appreciate the issues relevant to the proposed development. I've not yet undertaken any unaccompanied site inspections. I do intend to arrange these when I'm comfortable I have the most up-to-date information regarding the proposed development and any other proposals in the vicinity that may need to be considered cumulatively. I may also decide that an accompanied site inspection would be beneficial or necessary after hearing evidence during the oral sessions. If this is the case, parties will be notified in advance and invited to attend. Does anybody have any general queries about the code of practice or the options it offers before we move on to item 4? No, and is everybody comfortable that we follow the code of practice for this inquiry? Yeah, okay, perfect, thank you. So item 4 is, apologies if I look to different directions, I have screens around me. So item 4 is, we're going to look at what additional information is necessary to update the application. I've set out my initial thoughts within the agenda that was circulated. So as you'll see, I've suggested that I may need an updated cumulative landscape and visual impact assessment on the wind farm, taking into account any new wind farm proposals at application or scoping stage. Can the council or the applicant confirm if there are any additional schemes that are not included in the original landscape and visual impact assessment?
I can help there, sir, if I may.
Yeah.
There will be an update to the cumulative baseline that will be required for the inquiry because there have been changes. That update can be available by the end of May on the basis of an August inquiry date. But I do request that that information is required by you for the purposes of the inquiry under Regulation 20.
I agree. Yeah. Okay. So I'll be needing a hard copy of the updated cumulative assessment. Does the council require a hard copy or would a digital copy suffice?
I would think a digital copy will suffice, sir.
Okay, thank you. We'll speak later on about publicly available copies of information. So at the moment, we'll not touch on that. So thank you very much for saying that. So in terms of the timescales for the submission, I'd initially penciled in here 6 weeks from the note of the meeting, which had been 19th, but you're saying the end of May. I think that still works for my timetables. I'll just have to update some of the dates that I give out when we get up to that section in the agenda. We will shortly touch upon the potential implications of the recent Rayshaw ruling, of course. So if it's likely that any updated environmental information needs to be prepared and submitted, I'd expect that they're consulted upon at the same time. So there may be implications for that time frame again, but we'll come to that shortly. For the further written submissions on the subject areas set out in the appendix, I'll be suggesting 8 weeks from the issue of the meeting note, which would take us to the 2nd of June, but we can discuss the timing of that in more detail when we move through the agenda. An update would also be required on any changes to council or government policy since the submission of the application. This update can be given either as separate written submissions or as part of any session on legislative and policy context. If we agree later that such a session would be beneficial. Again, we'll discuss this further during item 5. We can pick up the issues about timescales for submission under item 8. But can I just confirm at this stage whether parties have any views on these updates before we move on to the other matters that are set out within item 4? No. Okay, that's perfect. Thank you. Okay, so within the applicant's original position statement, it was suggested a number of matters would benefit from further information, highlighting the need for additional environmental information, which would need to be subject to advertisement and consultation. However, during the December meeting, the applicant advised that this was no longer necessary. Can I just check with the applicant that that remains the case?
So yes, may I in fact address this bullet point under item 4 and also the 5th bullet point, because they go together very much, if you'll allow me to do so. You'll see where I'm going if I start. You can always stop me if you think I'm going on to a different topic.
Okay.
You received Brodie's letter of the 27th of March, seeking to defer the start of the inquiry until early December. Now, against that background, it's still the position as at today that no amendments to the project are proposed, which would require AI.
Okay.
However, the applicant cannot confirm that this will remain the case. As you recorded in the agenda, the UK government and Scottish government have issued draft technical guidance on SDLMIA for consultation. That consultation ends on the 15th of May. The governments will aim to respond to views given by consultees, we believe, roughly August 2026. They will then finalise the guidance, again, roughly August, and then regulations will be laid before the UK Parliament, which are necessary in the context of the guidance. Now, one of the key matters to be decided by the governments following the consultation will be the precise value of the seismic impact limit. That is, if you like, the limit on the amount of seismic ground vibration that can be caused by any individual project. The seismic impact limit is expressed in the consultation as a range of potential values, not as a precise figure. And the consultation asks for views on the single value to be selected from within the range. Now, depending on the value finalised by the governments, there may well be consequences for Teviot wind farm in terms of the precise numbers of turbines. It may be that at that point, the applicant will have to seek to make amendments to the number of turbines proposed within the development. Now, I acknowledge this is an uncomfortable position, but we have no influence on the timing of the consultation or its outcome, and it's later than we anticipated. And it was also anticipated until very late in the day that the consultation would be on a proposed single value for the seismic impact limit, not a range. It was also anticipated at the time of the first pre-examination meeting that matters wouldn't move more quickly than they have, but delays, and it's nobody's fault, not pointing fingers, delays in the issue of the MOD's safeguarding approach, published on the 18th of March, in turn delayed the current UK government and Scottish government's consultation, and hence the request to defer the start date of the inquiry. The applicant fully understands that no party wants further delay, but an August start date would mean that neither the applicant, and I believe, nor the MOD, will be in a position to evaluate the consequences of the still to be finalised or perhaps just finalised technical guidance for the development. If evidence was heard in August, it is almost inevitable that you would have to consider reopening the inquiry in order to understand the consequences for the project of the finalised seismic impact limit value. And that would have consequences for the evidence which is almost certain to be material to the position of the parties. Now, if I look at the matters you've set out against that background in Appendix 3 to your agenda for this pre-examination meeting, and look at your numbered questions, I'm not going to try and answer them. That's not the purpose of the exercise.
No, not
what I am saying is that if you ask me now, you are asking us now to make submissions within 14 days of the note of the meeting, what are the implications of the draft guidance for this case? Well, we just don't know, because the seismic impact limit is a range of values, and that matters very much to Teviot. Nor could we answer the second question you set out, nor could we answer the fifth question you set out.
Yeah.
So we'd be in some difficulty in making meaningful submissions at this stage. So, in consequence, In conclusion, I do apologise for putting you and all parties in this inquiry in this position, but we have no influence over matters in this respect, and I have to make this request. Thank you, sir.
No, I acknowledge the request. I think I don't want to preempt what I've got to say on the other things about timetables and whatnot at this point. Of course, we have to get through lots of different topic areas today. And the aim and objective is obviously to have an efficient process that's reasonable. I totally understand the position of the applicant here, and hopefully you'll understand my preliminary position a little more as we progress through the agenda today. And then obviously the intention of that further written submissions, which is taken totally separate from the further written submissions on topic areas. This is specifically so that I can better understand the relevance of the point we are. I think that it was worthwhile pausing from December, and I know that there was resistance to that, but I do believe that it's been beneficial. It's allowed that there has been steps taken that were anticipated. So I don't regret us doing that. The questions, just for clarity there, where I'm saying how in question 1, not to dwell on these at all, suppose the short answer in terms of the implication, it's I understand that you can't say what the finalized guidance's implications would be. But I think that it was more the materiality of the guidance in terms of my consideration of the proposal. So, not wanting to put words into anybody's mouth, it's quite clear in the guidance that it says that it shouldn't be used in the planning process at the moment in its draft form. I think I don't want to step too far ahead at this point. I think if we just sequentially go through each of the points, I understand your position, and hopefully I've got a pragmatic approach in mind for dealing with this topic area and with the other topic areas that I need to consider as part of the inquiry, and hopefully at the end of today we'll have some agreement, and if not at the end of today, at the end of the exchange that will be following the further written submissions. So if you'll bear with me and allow me to stick to my script, I'll continue from here, and we'll speak more on it shortly in the subsequent items. Thank you. Okay, so we'll have a quick look at the Rayshaw ruling before we move on to Eskdale Muir anymore. So I do intend to seek views from the applicant regarding the implications of Rayshaw as well on the proposed development. You'll see I've set out some questions again in Appendix 2. Given the technical nature of the information that I'm seeking, insofar as it's going to be an interpretation of a legal judgment, where I'm fully aware that there's no proven case law or precedent to draw from, I'm not going to enter into any debate on it just now. But you will see from Appendix 2 that I will accept comments on the matter from other parties that wish to opt into the process today, or that have already notified me that they want to comment on it. I'm sure the applicant's already given some consideration to this matter, because Rayshaw judgment is relevant to development proposals across the country. At this point, I'm going to initially make sure the applicant's happy with the procedure I've set out. I'll also welcome any indication at this stage, informally of course, of the potential scope of any necessary information in this case, and how long it's going to realistically take to prepare. I do see a raised hand. I'll come to that shortly, but I'll go to yourself, Mr. Trinick, just to respond to that for me.
Yes, thanks, sir. Bringing all the thoughts in Appendix 2 together, it's unlikely that any useful environmental information on the wind farm and the grid evaluated together could be produced for the purposes of the inquiry. The grid connection point has not yet been fixed, and so the route to that point is not known. I should say this is not unusual in many cases where the connection will be shared for some of the route with other projects, as it will be at Teviot. However, in the written submissions to be provided on this issue, what I'm going to invite you to do is to consider the imposition of a multi-stage condition on any consent granted for the wind farm. That condition will prevent the commencement of wind farm development until the Scottish ministers, I think it should be a Section 36 condition, are satisfied that adequate environmental information has been provided on the cumulative effects of the wind farm and the grid connection. Now, whether that condition would need to cover the whole route or only that part serving Teviot alone is a matter of legal submissions, and I'm not going to go into that now. But that is the approach which we propose. Of course, we could provide some pages of environmental information, a high-level view on the significant environmental effects of the intra-project effects between the grid and the wind farm, but I don't think that would be enough to discharge the burden on you to ensure that the likely significant effects of the intra-project significant effects have been duly isolated and described. Hence the approach via a condition.
Okay, so if you set that out and articulate that in your response to myself, I would very much welcome if you have some indicative wording of the sort of condition that you think would work. I know that parties in this call are itching to respond to what you've just said, but as I've said, I'm not going to enter into any debate on it today. But anybody, I'm going to invite in a moment people to opt into this process, and there will be an exchange of views that I'll take full consideration of, starting with the applicant. Other parties can respond, and then the applicant can subsequently respond in line with the timetable I've set out. So I did notice there was a hand. Providing that hand wasn't going to enter into further debate on this at the moment, I'm more than happy to go to that person. No? Okay, thank you very much for your behaviour and your accommodating nature. So, as I said, I'll now take the names of any other opted-in parties that wish to make representations on this matter. So if you just raise your hand using the raise button, I'll take a note. Dr. Ford?
Yes, we're more than happy to participate in the process and we'll make a contribution.
Thank you very much. And I have another hand there. Sorry, I can't. Let me see where you are. Oh, yes, Dr. Colby. Yeah, I do have a notification from Mr. Looking as well that he wants to make a representation on this matter. And I would assume that the council will want to comment on this.
I would imagine so, sir, yes.
Okay. And as I say, I will, if anybody else would like to opt into the process at this time, they can do. But no, I think that covers the bases then. Thank you very much. So the final item we've already touched on there being Estelle Muir. So I did set out the questions to better understand my position. You'll see from Appendix 1 that my initial view was that further information on the matter should be accepted as part of the applicant's closing submissions in its case summary. That said, my provisional position on that might change following that submission of the further information and all the publication of regulations or guidance in relation to the matter further down the line, or indeed following our discussion on the procedure when we come to that item on the agenda. I won't talk around it too much at this point because I don't want to dwell on it too much in this point of the agenda. In this point, it's just seeking the agreement that we'll go through the process on of the answering the questions set out there in Appendix 3. And I think we've already covered that the applicant, if you can do your best to respond to those and again articulate your position, that would be ideal. Can I just ask which other parties would like to be involved in that as well? Dr. Ford?
Yes, so we would like to be involved as well.
Yeah. Is Dr. Colby? Yeah. Defence Infrastructure Organisation, I've already set out that you'd be involved. I assume that you'd like to be involved in this exchange. And any other parties? Thank you very much for that. So we're going to go on to item 5, which is my provisional assessment of the main issues to be addressed and those requiring the further procedure. During this item, it's my intention to refer to Appendix 1 of the agenda. Can I just check everybody's got sight of that document or is familiar with the content? I'll start with those topic areas that I've suggested wouldn't be subject to any further procedure. So as I highlighted earlier, a number of the issues raised I don't consider require further information. I will, of course, consider in detail the information that's already been submitted on these topics in the preparation of my report. So looking over the table at Appendix 1, starting with the applicant, can parties advise if they agree with my findings on those issues that have suggested don't require further procedure?
Yes, sir, quite content. I anticipate that one or two parties may want to make representations on fire risk and safety, bearing in mind some recently issued advice on that topic. And we have no objection if we go in that direction, but otherwise we're happy.
Okay. Okay, so I'll work my way around. If anybody doesn't agree, this will be the easiest way. If you want to put your hand up, if you think that on any of those that are marked as having no further procedure actually need further procedure. And Dr. Ford.
Sorry, sir, I've been jumping ahead of you.
No problem.
Just
Okay.
holding to further, not proceeding further. Yeah. Okay.
Yeah. Okay. Yes. So then we'll move on to written submissions. Oh, Mr. Moffat. Sorry.
Hello there.
Hello.
Yeah, I was just going to say just a couple of things which you put to no further procedure. Your dark skies, the effect on the dark sky area. One of the here at Teviot Head, we've got the darkest skies in the borders. You can see that from from Google Space photography. Darker than the Galloway dark sky, darker than the Kielder. But we don't have, we have pristine skies here, but they're not necessarily represented with the dark sky centre. But that doesn't mean they're not here.
No.
And it's pretty much the same problem which we have with cultural heritage and archaeology, because there's never been a proper survey here. There's a rough survey done in the 1950s. That doesn't mean there isn't anything here. And in your cultural section, when you look at, for instance, the Tinley Stone or the Catrail, these are singular things. But the area, because it's never been surveyed, doesn't mean that there isn't anything here.
No, I apologise if my saying that no further procedure implies in any way that I think that there is nothing there. It's just that from my reading of the environmental impact assessment and the representations we have, I think I've got enough to consider that.
Yes.
I mean, if you think that additional information could be obtained and what the benefit of that would be beyond what's already been submitted, I'm more than willing to consider seeking further information on it. But from my reading, it has had some consideration, and I'm as I say, just because I'm saying no further procedure, that doesn't mean it's not there. It just means I have enough.
The same problem we have with sort of paths and things like that. We only have limited recorded paths for these hills. That doesn't mean that there isn't a whole network of ancient paths which exist but don't have any recognition. So that's the principal problem we have with this particular region and this particular application. If I can use the geology as an example as well, I was out at Scalf Hill the other day. I walk up there quite regularly. I came across some geologists from Arizona University who come out here every year to study the landscape. The Arizona University specialises in tectonic plates. And I didn't realise that here at the Teviot volcanic complex is actually a unique geological feature in the world because of the collision of the plates. Yet, if you go back to the original studies of James Hutton, when he studied Sycamore Point, he made reference to Jedburgh, he made references all up to Hawick, and then he stopped. And because this geological complex with its tight volcanic vents was never in the first instance recognised, doesn't mean it doesn't exist.
No, I agree. Well, I think one thing that we're going to come on to shortly is that I'm suggesting that we have a community hearing session, and what might be when we come on to that, I'll talk more around the sorts of things that can be raised in that. And if there are matters such as this where there is local concern and there are matters that you want to communicate around that maybe you don't feel has got enough attention so far, things like the dark skies and the geology, this might be an arena where you could present some evidence and communicate as a view. But we'll come on to that shortly if that's something that would be useful. Yeah. Okay, thank you very much. So in terms of the fire risk and safety that was mentioned there by Mr. Trinick, can I just ask, do any of the people that are here in the meeting want to be considered through further written submissions, or are they content that we have enough information on it? No? Okay. Okay, thank you very much. Okay, so aside from the further information I've already mentioned regarding the cumulative landscape visual impact assessment, and then any potential additional environmental information that may come through as a result of Rayshaw, which from the initial exchange there doesn't look like it's suggested will. You'll see from Appendix 1 of the agenda, there are a number of topics I consider to be best addressed through further written submissions. We'll talk through each of these shortly. So, well, what I would suggest is that we work through the list top to bottom. So number 2 there, the first item is cultural heritage and archaeology. The applicant had suggested a hearing session might be necessary to ensure and enable a full and fair testing of the evidence of each party. However, having reviewed the council's report of handling and the applicant's original submissions, I consider I do have a good understanding of the position of parties and the nature of the assets in question, which I do intend to visit as part of my site inspections. That said, I do consider a round of further written submissions would allow parties to crystallise the positions, response to those views expressed by others, especially because this was a topic area that forms part of the council objection. I'm going to initially ask the council and the applicant whether they agree with this approach, and if not, what specific information it's anticipated can be communicated in an oral session that can't be addressed through written submissions. I'll then go around the participants, but I'll start with the applicant. Can I hear your views on this approach?
Thanks, sir. Yes, we're happy to accept your view.
Okay, and the council?
Likewise, sir, we're happy to accept your approach.
Dr. Ford, I see your hands up.
Sorry, sir. Yes, I'm really talking about the landscape and visual effects area, and not noted in the topic, but we would suggest it should be included as a residential visual amenity assessment.
I have got that. I will come on to that. I have a representation specifically on that matter, and when I get through the list, don't worry.
Okay,
I'll come on to that. In terms of my suggestion for cultural heritage and archaeology, in Is there anybody, if you'd like to raise your hand, that doesn't agree with my suggestion for written submissions? If you do that now, I'll hear you out. Okay, that's perfect. Thank you. Right, so the next item is civil aviation and defence. The purpose of the further written submissions noted in the agenda is intended to draw the issues identified by NATS and MOD to a conclusion, and to demonstrate in the case of the NATS objection, the effects of the proposed development are capable of being mitigated through the use of planning conditions. Now, I have been advised, I see you're still here, but I have been advised that significant progress has been made on this matter, and it's believed that agreement can be reached. That's advised by NATS. To that end, I'll take further written submissions on the matter to seek confirmation agreement has been reached. And if agreement isn't reached, I consider it could be addressed through the proposed hearing session on planning conditions. Does the applicant and NATS agree this approach for matters surrounding civil aviation?
Yeah, not agree.
Yeah,
We agree.
Yeah, okay. So with regard to matters surrounding defence, and in particular Eskdale Muir, my provisional view is that in order to enable the inquiry process to progress efficiently and at a reasonable pace, I would accept the further written submissions on the matter. However, given the evolving situation, I don't consider it to be appropriate for this to be submitted along with all the other written submissions set out with Appendix 1. So in order that ministers have the most up-to-date information at the time of decisions taken, I was going to propose that the further written submissions were submitted at the same time as closing submissions. And depending on the outcome of that round of submissions and the status of the technical guidance regulations at that time, it might be necessary for further procedures specifically on this topic to be arranged. This could be oral proceedings depending on the level of agreement between the applicant and the MOD. I do, as I've said, acknowledge the applicant's suggestion would delay all the oral sessions because of the emerging guidance. We can discuss the timetable later on in the agenda. However, I do consider that the approach suggested for proceeding with the other topic areas, if possible, and then taking this further in submissions later on would be a pragmatic approach. It'd minimise the delay, but it'd be flexible enough to accommodate later considerations in what's clearly a critical topic area. We've been looking at the timelines. I don't want to step too far ahead here, but with the cumulative landscape and visual impact assessment consultation, the further written submissions I'm asking for Eskdale Muir and for Rayshaw, my initial view was that the second dates that I'd proposed in the agenda would be the more realistic and appropriate for taking the oral sessions on the other matters. Looking at that, if that were to go ahead, I'm not going to confirm that now because we've not discussed it, but that exchange after the closing submissions would actually be later than you would need to submit a hearing statement for sessions were we to have December sessions as suggested by the November, early December sessions as suggested. So at this point, I just wanted to ask if the applicant and the MOD were supportive of that proposed approach in principle, in particular the instigation of the round of further written submissions on the topic that had been triggered by the lodging of the closing submissions. I'm going to start with the applicant. I understand that there is a danger, and this is whether or not you feel that the risk is too great that there'll be sort of a magnitude of change required that would undermine the need for these the other processes. I'd like to proceed with things as far as possible, but still have that flexibility of dealing with the emerging guidance. Can I just get your thoughts on that? I'll start with you, Mr. Trent.
Thanks, sir. I'm going to deal first, if I may, with all the items in the third box in Appendix 1, because there are other items than Estelmere. So those are the easy ones, so I'll get those out of the way. In terms of the MOD's radar, an agreement was sent to the MOD in December, and we haven't had a response to that agreement yet. A report was sent. We haven't had a response to that report yet. We hope to reach agreement with the MOD, which will enable in due course the withdrawal of its objection, and that's all I can say at the moment. In terms of low flying, we anticipate that matter might be dealt with satisfactorily by conditions, but I can't speak for the MOD. Turning to Estelmere, I think, sir, the difficulty with your suggestion is that one factor of a range of SIL values has profound implications for the way that we approach the evidence. It makes all the difference. If the single value SIL is at one end of the scale, it'll say something about Teviot. It's at the other end of the scale, the position will be very different. So that any evidence you take, whether in writing or otherwise, in advance of knowing that single value, I think the evidence will have to be completely revisited anyway. And therefore, I do wonder about the logic of taking evidence at this stage. Indeed,
I'm asking about the evidence and closing submissions, which would be, you'd be looking at the beginning of November, in mid-October, sorry.
Maybe
the beginning of November. So at that stage, yeah, if the timeline that you've set out comes about, then surely you'll know what you need, because the hearing statements that if we were to have oral sessions in November, you'd have to be submitting your hearing statements in late September. So this is actually giving you more time to respond.
Well, first of all, sir, I'm not sure I agree with your proposal to build further process on the basis of closing submissions, because the inquiry will have closed. I know you can always reopen the inquiry, but surely it's better to have one set of closing submissions, which takes full account of all the evidence at the very end of the day, rather than have.
Well, we could do that. I mean, I suppose me saying triggered by closing submissions just gave a little bit longer. We could trigger it using the same time frame, but when the further written submissions round concludes, the closing submissions are submitted at that point.
Well, sir, I think maybe for today's purposes, if we stick with the approach set out in your Appendix 3, and you hear what we have to say and what the MOD has to say, yeah, then I think you'll be in a better position to determine procedure. But I'm certainly very worried about the thought of giving evidence in any form about the Estelmere issue in advance of knowing that final SIL value, because that final SIL value may well lead to the need to make amendments to the scheme itself, unpopular though that may be. It could be that important.
Yeah. Okay. Well, what we can do is, I mean, at the moment, I see no requirement for a hearing on this. I mean, in the current procedure, the current policy that we have, we know the position of the MOD, and I don't think that a hearing had been necessary if we were to just proceed ahead. So I think further written submissions is the way. But as you say, anything in advance of the adoption of the guidance would be premature, which was why I was suggesting the later date for the further written submissions on this topic, so that you were fully informed about that guidance. But I think the best way, rather than talking through it now, is to have everything fully put down by yourselves in that response to the further written submission cycle that will take place over the next 6 weeks, and fully explain, so that I'm aware of the implications of that approach. And I think you'll see from the questions I do ask, what are the risks and benefits of this approach. And if you articulate those and set them out to me, at that point, a final decision can be taken on the appropriate course of action.
I'm very happy with that, sir. Thank you.
Okay. So in terms of, I'll just ask the MOD as well. The potential for receiving further written submissions later on, and that potentially triggering, if necessary, an oral session after the event for this matter in particular. Would you be supportive of the approach that I've set out?
In broad terms and in principle, yes, sir. As you're aware, the MOD's position is quite clear and makes the present application, albeit now impossible, I suspect, for USER to grant permission. Otherwise, you never jump the gun in that regard. We know that there's ongoing consultation. We know that there's already been a delay in the anticipated timeframe for that, noting that in December it was thought that regulations would be laid before Parliament in May. That's clearly not going to happen. There is an anxiety that November, December may even then be somewhat ambitious. There will be an output from the consultation, of course, that will result in some form of SIL, one would imagine, as set out in the MOD's most recent position statement, having regard to the technical guidance, the draft technical guidance. This development will be challenging, or quite challenging as the case may be. It may be impossible, in which case the submissions could be relatively short. If it's in the challenging or quite challenging category, it seems to be inevitable that further sessions of this inquiry would be required. So the position I suggest, sir, is that if the Eskdale-Muir chapter of this inquiry is to be addressed, having regard to future regulations or guidance, it is speculation to know where that might end up. And it may be, as I say, ambitious to suggest that it could be resolved simply by exchange of written submissions. My own gut is that you, sir, if you're minded to continue the matter to see how the policy position evolves, my own gut position is that some form of inquiry, whether that be by hearing or inquiry session, will be required. I think it's appropriate that I flag that up at this stage. But maybe, as you suggest, sir, we do baby steps and see where we end up.
Yeah. No, that's very useful. Thank you. Thank you very much. Is there anybody else in the call that wants to add anything at this point on this matter?
Yeah. And sir, I wonder, Mr. Milne reminds me that perhaps we might also want to touch upon radar, I should say, under section 3.
Yeah, well, what I think, what I believe is that what I could do is, I think, yes, as I've gone through this, I've truncated the list,
yes,
from as I see it in there. So what I would propose to do is, when I issue my note, is to modify number 3 to introduce another bullet point beneath the first one, to clarify that the confirmation from NATS and MOD identified issues have been resolved, relates to all issues excluding Eskdale-Muir. I think that's what I meant to say.
No, I'm sorry, sir. I think we may be talking at cross purposes.
Oh.
And I wonder if I might invite Mr. Milne to address you briefly on this topic.
Okay. No problem.
Thank you. Good afternoon, sir. The MOD's position as regards their air traffic control radar objection is that that objection is maintained. The MOD has reviewed the mitigation proposal, which has been put forward by the applicant, and that proposal is not acceptable.
Okay.
Now, it may be that further discussion will take place, but as presently advised, the MOD's objection regarding impact on air traffic control radar is maintained, and I would think that some form of oral procedure is going to be required to address the technical and operational aspects of that. And it may be, although perhaps this could be revisited if progress is made through further discussion between the parties, that come to an inquiry session would be appropriate to deal with that ground of objection.
No, I understand that now. Thank you. Mr. Trinick.
Thank you. Sorry to disturb the even tenor of the pre-examination meeting. I find it rather disappointing that, having submitted a report in December, the first response we get from the MOD is from its lawyer in the pre-examination meeting. We had no idea that the proposals put forward were unacceptable. We had no idea at all what the response would be. So I'm a bit disappointed to hear evidence this way. I'll say no more. Thank you.
Okay, so touching on this then, I have two options here, I suppose. What I could do is, when we come to the scheduling for the oral sessions, include a preliminary slot for this matter, and then if agreement is reached in advance, we'll just cancel that slot. Alternatively, we could do it through further written submissions, and if agreement isn't reached by the further written submissions date, we can set a slot. I don't think that, I mean, parties may disagree with me, but I think that this doesn't necessarily need to take place in person. If it's a later arrangement to arrange this, I think that we could possibly do this technical discussion on a virtual basis, and therefore maybe don't have to plan for for the ATC radar as part of the local public inquiry sort of sessions that we're doing. We could maybe tag it on the week before or the week after as a technical session that people can still be involved in, but then it's easier to cancel that if needs be. What are your thoughts on that, Mr. Trinick?
That sounds a very good idea.
Would you support the further written submissions approach, and then we'll look to arrange a session if agreement can't be reached at that stage?
Sorry, sir, that's what I thought I was saying. It's a very good idea too.
Okay. And would that approach suit the MOD as well?
Yes, sir. That is acceptable, helpful way of narrowing the issues, if nothing else.
Okay, so I'll do that, and I'll make sure that's included in the note of the meeting. Dr. Ford.
Thank you, sir. Just coming back to the Estailmuir issue, assuming you've wrapped up the topic in terms of air traffic control and so on. You asked for parties' views. Obviously, first of all, we support your process of looking for comments in the next few weeks or so, and we'll support that process. But two other points here. One is that in general terms, these inquiries and these cases are always conducted on the basis that future policy changes or changes to policy or rules or anything else like that are given little to no weight. And we need to take that into account, along with the general obligation to have a timely and fair process. I appreciate there's got to be some accommodation for Estailmuir in this process, but we should also be recognising the fact that we do not give weight or to policy changes that are going forward in the future, just because the doubt about it. And as you've already pointed out, sir, the consultation guidance is actually very clear in saying that it shouldn't be impacting on current cases. So just to reiterate that point is our general position. Thank you, sir.
Oh, thank you very much. Okay, thanks everybody for this for the comments on that point. That was, I think, always going to be the trickiest one to navigate at this point. Okay, so the next matter in the list is ecology and ornithology. You'll see from the information that I consider is required on page 5. You can see the information required. Do parties agree with the scope of this information that I've set out? I suppose this is, yeah, this was responding to the position statement of the applicant.
Or are you asking me?
No, I'm just asking in general to the if people if anybody if everybody is was happy with the scope of the further written submissions. Yeah. Okay, perfect. Okay, so forestry is number 5. So the next matter that I'd like further clarification on is the level of commercial forestry that would be required to be felled to facilitate the development and the full details of mitigation. Does this make sense? Again, this was, I suppose, in response to the objection from the council and the details provided by the applicant in the position statement again. Is the scope of that, are people happy that that covers what we need? Mr. Trinnett?
Yes, sir. Thank you.
Thank you. Yeah. Okay. So I would now like to move on to the effects of the proposed development on tourism and recreation and its overall socioeconomic effects. Representations have been submitted in relation to this matter by a number of third parties, many of whom have opted into the inquiry process. I consider that further written submissions regarding key recreational routes, viewpoints and assets that would be affected by the proposal would help me to better understand the position of parties. I'd also welcome information regarding the anticipated effects on any specific tourist facilities. For further written submissions on this topic area would also enable the applicant to provide further information regarding how any identified effects, for example, on recreational routes would be mitigated and to detail any other socioeconomic effects. I'm satisfied at this point that following the receipt of the information, I'd have enough on this matter to accurately relay the position of parties to ministers. However, I've already spoken about a community session, and I would imagine that this will come through that session as well. But for now, parties confirm they agree this is the most appropriate manner to obtain all the information that I need. If anybody doesn't agree, just press the raise hand button and I'll come to you. That's great. Thank you very much. Okay, so we'll now move on to legislative and policy context. Parties will have that have been involved in Section 36 inquiries before will be aware this subject is generally addressed through a hearing session. Usually between the council and the applicant, and in this case the applicant has suggested such a procedure. However, I don't know if I'm 100% convinced that such a session would necessarily add benefit or be the most efficient use of our time. So my initial position as set out in the agenda suggests that matters surrounding legislative and policy context could be effectively considered through further written submissions. It may be the case that following the submissions, it becomes clear that an oral session is necessary, however. But given that this is likely to be a specialised topic again, with limited contributions, I think it's another one that could be arranged as a standalone session if needs be. I'd be interested to hear the views of parties on this suggestion, and in particular to explain what value they'd consider an in-person oral session could add. So I'll start with the applicant.
No, sir, I'm happy with what you suggest. I've noted particularly that the exchange of submissions may lead to a need for an oral session. That can be decided later, but on that basis, we're content.
Okay. Would anybody else like to, Dr. Ford?
Yes, sir. We're also happy in principle with that process. It's actually very similar to what we're seeing with other cases across the country, basically with the provision being made for potentially half a day or something like that of a policy session. The other thing to bear in mind, of course, this application was lodged in 2022. Policy's moved a fair bit since then, so there might be a lot to catch up on.
Yeah, so I think that the round of further written submissions should catch that, hopefully. And if there's any significant areas of disagreement that I need further clarification on, I will call together a session. Is the council happy with that approach?
So I mute myself. Yes, absolutely. We're quite satisfied.
That's grand, thank you. So, okay. Right then. So, I think we've got through. So that was number 8, wasn't it? So, given what you've said, I'd agree that further written submissions is the best way to address it. We can talk about the timetable later in the agenda. But before I do move on to those sessions that require oral sessions, I do want to turn briefly to residential visual amenity, which Dr. Ford raised there. In my previous agenda, I made it clear that if the proposed design and layout of the scheme was to change, then the additional information would be required to update the residential visual impact assessments. That was when we thought that there may be a need for additional environmental information. Because at this stage, there's no indication that the scheme layout will be amended, I'm satisfied that the current assessment is the most up-to-date. I appreciate that this is a particularly sensitive matter, and it's important to many of those that have opted into this process. I have been asked by a third party to include it in any oral session focused on landscape and visual impact, because there's a disagreement between parties on the effects. However, I believe I have sufficient information to consider it, perhaps subject, of course, to some site inspections. That said, it's important that I fully appreciate the position of the parties on the matter. Therefore, I'm going to propose to accept further written submissions specifically on the residential visual impacts. Any submissions should provide a position on the submitted residential visual impact assessment, and they should highlight any concerns with its accuracy or its conclusions. If after reading those submissions I consider that there's further procedure necessary, I'd make the necessary arrangements. Furthermore, of course, I am going to be suggesting a community hearing session today where local residents will be able to provide evidence on all areas of concern. Does this sound like a reasonable approach to ensure that I fully appreciate the position of parties on this matter, Dr. Ford?
With respect, sir, I'm going to disagree. And that's from the point of view of, just to point out here, sir, we will be leading an expert witness in this, in landscape and visual impact. She will also cover residential amenity. And it seems to me like it's almost a necessary process to add a further written stage when it actually fundamentally ought to be just put together with landscape and visual impact. So I would respectfully suggest that we don't have an extra written submission. We just simply put it into landscape and visual impact and deal with it there. I think overall for all parties, it will involve less work. And, and I do feel at the end of the day, you've recognised it's an important topic for the local community. But we have done quite a lot of professional work on it, and therefore we're in a position to lead evidence on it.
Okay, so you have a witness. So just so that I fully appreciate the situation here. So is there a dispute in the accuracy of the assessment itself, or is it the acceptability of the is it the findings, or I don't know how to say this? Is it
the outcome?
Yeah. So is it the methodology for the assessment and the accuracy of what's presented through that assessment, or is it the assessments of acceptability that is the main point of dispute?
I would need to go and look at our experts' views that she's put forward to actually be absolutely certain about that, but I think it includes both parts. So,
okay. Can I just ask Mr. Trinick here to come in with your thoughts on this? This isn't something that in the section 36 inquiries I've done before, this has not been a matter that's been included in the landscape and visual impact assessment, but you may well have more experience on this than myself. Does the applicant have a view on this suggestion?
Well, actually, so I agree with Dr. Ford. you're going to get the information in writing one way or the other. So I think it's far better that it should be wrapped into the landscape and visual evidence and be subject to discussion or examination, whichever it is, the inquiry.
Okay.
And the inquiries, the last few inquiries I've done, that's been the process. I think it works perfectly well. I don't think that we need to introduce further written submissions, as you've suggested. Just do it as part of the landscape and visual inquiry.
Okay, I'm happy with that. Thank you. I've updated my notes. Okay, so thank you everybody for your time so far. We're about to move on to, let me just see where's a good time for a break. We're about to move on to the oral sessions itself. Would anybody like a brief comfort break at this point, or would you like me to carry on? Everybody's happy? Okay, oh, this is good, thank you. Okay, so on page 6 of the agenda, issue 7, let me just get to my appropriate area. Yes, so page 6, issue 7 requires the applicant liaise with the council and other relevant parties to prepare a set of draft conditions. Again, we can discuss the time frame for submitting these under item 8. However, it'd be useful to know at this stage if there's been any progress so far on conditions. I have a series of questions. I'll start with that one. Has there been any progress so far?
None, sorry, sir, none so far.
Okay, no problem.
But we are willing to draft a set of conditions as you've suggested and circulate those.
Okay, so is there any views at this stage as to when they may be available?
We'll take a wild leap and say about 6 weeks.
Okay. So what are the parties' views on the suggested approach for preparing them in advance and then considering them in a dedicated session if agreement can't be reached? It's quite standard. Parties happy with that? Yeah. And do parties feel that a hearing focusing on the areas of disputes the most appropriate? I think we need to have it. I think there is benefit if there are any conditions that haven't been agreed to come together to discuss those. Yeah.
I agree, sir.
Okay, thank you. Is everybody else satisfied with the approach set out? Yeah, thank you. Okay. So we've spoken about cultural heritage and archaeology as further written submissions and the potential for a planning and energy policy context session subject to the outcome of the further written submissions. Okay, so before we consider the possibility of holding a dedicated community session, I did want to come to the landscape and visual impacts. I'd originally suggested that issues surrounded this could be addressed through a hearing. This is because I didn't consider initially that there was substantial disagreement between the parties regarding the effects. It was more focused on acceptability. However, I appreciate that the applicant has suggested an inquiry would be the most appropriate means to consider the topic, and the council agreed to that. I also am aware that Dr. Ford has got an expert witness there that wants to contribute. So I wanted to discuss the potential benefits of having a formal inquiry session with expert witnesses presenting evidence and being subject to cross-examination. Is it the case that there's been benefits to this, or do parties think that a hearing session would be acceptable? I'll start with yourself, Mr. Trinick.
So we remain of the view that an inquiry session would be appropriate. We think that will best inform you of the differences between the parties, bring out with clarity those differences.
Okay. And the council?
Yeah, I would just echo Mr. Trinick's comments. I think there's some merit in that.
And Dr. Ford, are you and your witness for the conservation group, are you happy being involved in an inquiry session?
We're open-minded, so we don't mind either an inquiry or a hearing session. We'll work with whatever happens.
Okay. Well, I think from what I've heard, an inquiry may be the most appropriate to consider in it. Obviously, we'll need precognitions and whatnot, but I'll send full information on that. Yeah. Okay. That's good. Okay, we'll stick with the inquiry. Has anybody else got any comments on that, or is everybody happy with that being the approach we take? Yeah. Okay, so the community session. So given that the sessions we've already discussed would likely involve professional debate between expert witnesses and legal representation, I did also want to explore the possibility of having a dedicated community session, perhaps during an evening, to maximise the potential for affected parties to attend, to raise any views or concerns in person with myself. In other inquiries that I've managed, there's sometimes been an appetite for this, and in others there hasn't, with people more comfortable submitting the views in writing. But I'm going to work through the community councils and those parties that are participating as individuals to see whether or not there'd be an interest in a dedicated session for the local residents to air the views. Direct participation would be restricted to those that submit a hearing statement in advance, in line with all of the other sessions, which is standard. That's not to say that people who have opted in can bring witnesses from the community, providing those hearing statements are provided in advance. Yeah, so if you have a view on this, if you raise your hand, I'll work my way around the attendees and we'll make an agreement. Dr. Ford?
Yes, we would certainly like a community session. What I will try and do is to organise it in an efficient way so that it's not repeating and that it's coherent in giving you some information from the community. But we would appreciate it.
Oh, that'd be welcome. What we tend to do is parties would submit their statement, which is their argument. I wouldn't have people read them out or anything like that. They'll all be taken as read, but I will probably have questions for individuals just for them to more fully explain a point if need be. It wouldn't normally be these sessions where, I mean, the applicant may well attend, but it's not generally in any way confrontational or grilling, and whilst they may want to provide a bit of clarity or a response on a given point, it's more for the public and the community to express their thoughts to myself. I'll work my way through the community councils then. So I'll start with Upper Teviot Dale.
Thank you, sir. Yes, I think we'd welcome an opportunity to have a community session. We've participated in one public inquiry before and found the community session quite useful.
Okay, perfect. Thank you. And Liddesdale and Hermitage.
Hello, can you hear me?
Yes, I can.
No, my camera seems to have gone off. Anyway, yes, we think that it would be very beneficial to have a community session so that you can gauge the feeling and the views of the local communities.
Okay, thank you. And South Dean, are you happy with that as well?
Yeah, I was just going to check on the potential timing for lodging of the hearing statements and when you might be planning this, given that cumulative impact in particular is going to be an issue. And therefore, just wondering what your timing was. I would certainly think that would be a good idea and would intend to participate in that. Thank you.
Yeah, I will go through the timings shortly. Well, shortly, there's a few pages here, but we will go through the timings. Generally, I ask for the statements 4 weeks before the inquiry session. And then 2 weeks after that, I'll circulate an agenda to all parties that are going to opt in, which will detail my specific questions for different people. I like people to be prepared, so I'm not putting them on the spot.
Yeah, so given the fact that cumulative are likely to be an issue, obviously the updated cumulative guidance will be of assistance, whether that's pre-SIL or post-SIL, because obviously that might change as well, but that was the end. Thank you, sir.
No problem. Is that Pat I can see there with your hand up? Sorry.
Jane Bauer, so.
It's Jane, I'm sorry. Sorry, Jane.
Yes, I think it's an excellent idea. I think there will be a lot of local interest in hearing what everybody has to say and in contributing through written submissions.
That's good to know. Thank you very much. And is the applicant happy with this proposal?
Yes, very happy, sir. It's very worthwhile. And as you've indicated, we certainly would not intend to do other than attend and listen.
Yeah. And if anybody else has got a hand up, please feel free to chip in.
Yes, I would certainly welcome a community input. And Stuart, if I can invite you to the Borderlands Museum to have a look around. When you come on your site visit, we've got the only representation from the Iron Age through to the Reavers, which represent the landscape, which you'll be looking at. And our initial contact with Muirhall Energy, you'll notice in the application which they put in that we're not included at all. Although we've been here for over 40 years and we have visitors come from all around the world to visit the collection, we were told that we didn't exist by Muirhall Energy, which gives you an insight into what kind of company you're dealing with. But if I can welcome you to a museum visit, that would be nice to see you.
Well, I wouldn't commit to anything at this point. What I would say is that if we have a hearing session and that offer is made at that point, and a decision is taken that an accompanied visit would be appropriate and beneficial, of course, subject to agreement and accompaniment by the represented parties, including the applicant, then maybe that's something. But it depends whether it'd add. Obviously, I have to be impartial and I have to look at this.
Of course, yeah.
Totally objectively.
Of course, you'd be welcome to have an unaccompanied visit. But as I say, you know, this area of the world is quite unique culturally, historically. It's like nowhere else. And that isn't really represented very well, but we do have a physical representation of that. If you want to look around on your own, just to make your own opinion about things.
Okay, thank you very much.
I'll have to go now, by the way, because I've got an appointment elsewhere, so I'll say bye for now.
Okay, thanks for your time.
Thanks.
Okay, so with that, we are into item 6, which is participation in further procedures. So we're now going to discuss the different topic areas to establish which parties wish to give evidence, the number of witnesses to be called for the oral sessions, and the length of time that the oral sessions are envisaged to last. I aim to issue a note of this meeting within 7 days, although obviously we've got the Easter weekend, so there may be a slight delay, but it'll only be a day or two if there is a delay. And then once the note's been issued, parties will have a maximum of 14 days to confirm which topics they wish to give evidence on. This applies to both written submissions and in-person sessions. Whilst the mechanism for participation in each subject area is ultimately triggered by that written response, it would assist my own planning to go through the different issues now, just to take a note of those that would like to give evidence so I can include it in the note of the meeting. So we're going to start with the written submissions. I'm going to work my way through the list now, and I'll ask for a show of hands for those parties that wish to provide evidence on each topic. And once I've written it down, we'll move on to the next one. So I'm going to start at item 2, which is cultural heritage and archaeology. If you just pop so we've got Dr. Ford. Are there any other individuals? If you just use the raise hand function, I'll be able to see you on my grid and write your names. I'm assuming the council is going to be involved in this, given the objection, the grounds of objection.
Yes, we will, sir.
Yeah,
I was assuming you're inviting indications from other parties outside.
Right, sorry. And the applicant. So yeah. So I have Dr. Ford, the council, and the applicant. Would anybody else like to? And I think obviously although he's just departed the meeting, I'm assuming that the Borderlands Museum would be interested in submitting on this. Of course, he'll confirm in writing, but from what is said already in the meeting today, it seems that he would be. Anybody else? No. Okay, thank you. So then we have the civil aviation and defence. So we'll start with the civil aviation side of things, which is the NATS. Obviously, NATS has indicated that they wish to be involved in that. Does any other party have a desire? No, so that's just the NATS and the applicant. Okay, and then in terms of defence, we're talking about the other issues here that we got clarity on there for item 3, which is the excluding of the Eskdale Muir side of things. Of course, we'll have the applicant, and I would assume the MOD is going to be heavily involved in this one. Yeah, and any other party? No. Oh, Jane?
What about Dr. Colby as an expert witness in that one?
Well, this is for the written representations in the first instance for those matters that that have been subject to objection from MOD. So the matters that are still in dispute. I don't know if he's already submitted representations on that ground. What I can do is when the note goes out, if anybody else at that point thinks that they'd have a meaningful contribution to make, and more than happy for them to contribute and opt into that process. Makes sense.
Okay.
Okay, thank you very much for that. We'll put in the note of the meeting that suggestion was made, though. In terms of ecology and ornithology, Dr. Ford? And the applicant, is there any other party that wishes to add anything to that subject at this point? Forestry. I think this was one of the subject areas of objection from the council. So,
Yeah.
Yeah. So the council, any other parties beyond the council and the applicant for forestry? No, thank you. Tourism, recreation and socio-economic effects. I have 2 members of the public that have pre-advised that they want to submit representations on this matter. Dr. Ford. Any other parties? Yeah. Community councils. What I can do is, if the community councils would like, I can put all community councils down for this one, if that seems reasonable to you. Yeah. Okay. I won't want to preempt it. You will need to confirm in writing still, but okay. Okay, so the legislative and policy context. We'll have the council and the applicant and Dr. Ford. Any other parties? Dr. Colby? Yes. Okay. And then we agreed to take the residential visual impact assessments into the main landscape and visual inquiry session. So in terms of the oral sessions, as discussed here earlier, yeah, So hearings are structured discussions which I'll chair. So also remember to bear in mind that we've agreed to hold a dedicated community session. What I'm going to do is just work through this. So I think that the conditions is the first on the list. Planning conditions, I would imagine the council and the applicant from the representations I've received, subject to agreement or otherwise on matters of civil aviation, NATS would want to be involved in that. And are there any other parties that would like? Dr. Ford?
Provisionally, sir, depends on what the content we get to.
Okay. And yeah.
Sorry, if I may raise on behalf of the MOD, if conditions are to be discussed in respect of the MOD's objection regarding the array, and or conditions to be discussed in the context of the MOD's objection on the basis of air traffic control radar, I wonder if it might make sense for that those discussions, if required, to take place in the bespoke sessions for those topics once the evidence has been heard.
Yeah.
Obviously, a lot's up in the air, but that might be the most appropriate way of dealing with those specific conditions, potential conditions.
I think that sounds reasonable. Is the applicant happy with that?
Yes.
Okay. Other parties happy? Okay, thank you.
Yes, we would participate as well, potentially.
Right then. So in terms of the other matters that could potentially be subject to a hearing, would be subsequent to a round of further written submissions, and I already have the opt-in information for those. So that brings us to the community session. Normally the council and the applicant would be there. The council normally is just there in an observatory capacity. They don't actually sit at the table or take part. However, certain councils may wish to have a more active role. I'll let you confirm that in response to the note of the meeting, if that works for Borders Council.
It does, sir. Yeah, I think we've only previously taken a viewing role rather than taking any part. So I don't see that changing in this one.
Okay. And I think that all the third parties and community councils, I would imagine, would want to be involved in this. So could you just put your hand up if you don't want to be involved, and I'll exclude you that way. No, that's fine. I appreciate that. Okay, perfect. So then we come to the landscape and visual impact inquiry session. So on this basis, so we agreed that we'd have an inquiry session. So can the applicant confirm your attendance and the amount of time you think should be set aside from it, based on the number of witnesses that you're likely to present?
So I'll be presenting one witness. I envisage knowing the parties are going to be involved, that you should set aside 2 days for that session. It may take less, but it could take 2 days.
Okay, perfect. Thank you. Can the council confirm your attendance and the amount of time you think should be set aside, based on the number of witnesses you're likely to present?
Yes, I can confirm the council will be in attendance with one witness also, and I would agree with the Trinic. 2 days should be sufficient, hopefully less.
Okay, perfect. Dr. Ford,
Yes,
you have mentioned one witness.
One witness, and we agree with Mr. Trinick as well, up to 2 days. We might well get it done in a day and a half or even less, but see how it goes.
Okay, well, we can all channel our positive thoughts on that one. Let's hope so. So do the community councils intend to participate in this, or will you be presenting your cases at the community hearing and just attending in an observational capacity? Mr. Kerr?
Yeah, can I just confirm, obviously, the community session will be before the hearing, the inquiry, because if it is, then that will probably allow those positions to be aired and then one can sit thereafter.
What I've tended to do in the past, we can come on to this in a minute when we look at scheduling. What I've tended to do is have the inquiry sessions first, just so that people can raise things after hearing what they've heard. I mean, providing it's included in the, I mean, we tend not to go too deep into the technical side of things, but it gives people a chance to reflect on what they've already heard. But if you think that front loading things, I mean, that may work better. I've just not done it before. I'm happy to talk about the arrangements. What I'd normally do, I don't want to prejudge where things. What I'd normally do is I'd aim to start on the first day with the inquiry sessions and get those out of the way, and then move on to the hearing sessions. And historically, I've had the community sessions on either the last day or the evening before the last day, just so that they've had a chance to experience everything that's happened. But I'm open to suggestions from, it's your community, you know your community better than myself.
Well, there are a number of community councils on here, and I daren't speak for all of them without that devolving to their input.
What we could do is, if we're going to have an evening session, it's not going to interfere with the scheduling necessarily for the other topics. So what you could do is express your preference as a group in your response to my note of the meeting, and then everybody can put their heads together and decide what's most appropriate.
Well, as the host community, I suspect Mr. Douglas will have a view, as will Mr. Colby, and I'm keen to hear what they also have to say. So,
yeah, Mr. Douglas.
Yeah, I'm quite open. I quite like the idea of having it after the inquiry sessions, and then we can pick up anything that we think maybe hadn't been covered adequately. I think we've given our response to landscape and visual effects and RVIA in our response already, so I don't think we have anything to add to that. But as I say, after the public inquiry session, if there was anything extra we wanted to pick up on, then we could mention it at the community session.
Dr. Colby.
Yes, apologies. My computer seems to have forgotten where the camera is, and so I'll be here sound only. Just to say that we also think that the community session should follow the inquiry session, so that, as you very wisely say, that we can pick up on matters that have been reflected upon after the inquiry section. Thank you.
that's acceptable. Yeah.
Okay. And does the applicant have any views at this stage? Are you happy with the process that's been described?
So from experience of past inquiries, I think the community session best follows the landscape and visual session, because the evidence given by the expert witnesses will inform those who want to speak at the community session. I think that's the best way around.
Okay, perfect. So we'll bear that in mind when we come to the actual scheduling in a moment. At the moment, I've got 2 days. I think that's I'll be very impressed if we can get through an inquiry and session on landscape and visual in 2 days. I may err on the side of caution and just give us the morning after as well, just in case there's an overflow, but potentially use that as an accompanied site visit if needs be, if we need to do one. So in terms of that, I believe is all of the different sessions. So we're just looking at dates, location, and likely duration next. So this leads us to the discussion on the earliest possible dates. As you'll see within the agenda, I suggested sessions take place during either August or September. The latter date I considered to be more realistic, given the additional matters covered by the further written submissions requested at Appendix 2 and 3, which would be the week commencing the 28th of September. I know the applicant has suggested that the sessions be postponed to November, December to allow the emerging guidance to be finalised. However, at this point, I'm not overly convinced at this stage that an oral session is required based on the current situation. I have suggested the further written submissions as part of closing submissions. If at that time the policy regulatory framework's changed, we can arrange further procedure as we've discussed. I've looked at my calendar, and if I were to agree to the suggested dates, as I said, I think that any hearing statements would be required earlier than the closing. Well, if we don't do it through closing submissions, apologies, we did discuss that. So, I mean, I'm not convinced that there's benefits in delaying the inquiry. I mean, after we've had the round of further submissions on Eskdale Muir, I totally reserve the right to change my preliminary view on that. But at this time, I'd like to just check availability for that week, and I'll start with the applicant.
So we're available in the week beginning the 17th of August. The week beginning the 28th of September is more difficult, although I acknowledge it's because I have another inquiry fairly soon before the 28th of September. So it's however, what I would say is that I think we need to get the exchange of representations on Eskdale out of the way, so that a final decision can be made on when to start the inquiry before we start timetabling too much.
Yeah. Is your other inquiry the week before, or is it very close? That would starting the sessions later in the week be more useful for you, given the aspiration, given the projected only 2 days for a session, plus a half day for the conditions and potentially the policy legislative side. We may be able to start and do it for the latter half of that week.
You're being very persuasive, sir. Yes, all right.
Thank you very much. That really helps me. And it helps my webcasting team. I'm sure they're breathing a sigh of relief. I do think it's important for us to do this in person. And I think that you'll be aware of the level, the workload that our division is dealing with at the moment with regards to lots of different things, and not only are our support staff and the reporters dealing with larger volumes of casework, but our webcasting team in particular are. So we really do need to book these sessions way in advance. So what I'd suggest is if we were to start on the Wednesday of that week to Friday, and we did Wednesday, Thursday for the landscape and visual, Thursday night for the community session, and then Friday for the potential sessions and the conditions and the policy and legislative framework. Does that seem reasonable to people? If for any reason the landscape and visual doesn't conclude within 2 days, I'm content that we can take the policy and conditions to virtual sessions and arrange for those to take place afterwards. I think that the community is going to be more interested in landscape and visual and in the community session, and maybe doesn't have the same level of desire to participate in person in those drier sessions. Does that sound reasonable? Trinick, are you going to accommodate me further?
I'll try, I'll try, sir, but having said you've been very persuasive, would you allow me a few days to come back to you on that date of the 28th of September?
Yeah. Yeah, we can come, if you let me know as soon as possible.
Will.
And we can review the other options. I just think that the earlier dates, whilst you're available on those, and I think that the danger with doing those is, given the 6-week exchange that we've got now on these two separate things, and the need for the cumulative landscape visual impact assessment update, I think that things are going to be cut pretty fine for the August dates. And I'm not 100% convinced that we're going to have the time to get everything in time for that now, given this extra step that has been introduced.
Well, I will get back to you, so I'll be as helpful as possible, but it's fair to say I do see problems. And I'm also very mindful still of the written exchanges on SDL Muir, which may end up determining when we start.
An alternative, if you're looking at alternatives, and I know this is pushing things further, and the 12th, the week commencing 12th of October, there's availability with our teams. So when you come back to me, if you let me know the two different, that would be ideal. And then we'll firm it up in the note of the second note of the meeting.
I'm going to just say, sir, I think your team, communications team, is actually busy the week beginning of the 12th of October.
Is this right? If I got the wrong, bear with me. Apologies. This is bad when your information it's more up to date than my shared calendar.
Put it this way, I can't make the 12th of October week either.
Okay. Well, what I'll do is, how about we stick with the week commencing 28th provisionally at this time, and when I write up the note of the meeting, I can give an alternative date that's been confirmed, just in case that one isn't doable, so that people can check with their witnesses as well that they're available that week. I want to be as accommodating as possible for all parties on this one.
If the applicant is available in late August, can I suggest that if we're moving well ahead with the submissions, I appreciate the 6-week submission period you've got to contend with, but can we keep that as one of the reserve options here rather than just shutting it out?
So if I may come in and agree with Dr. Ford, I would not want to sacrifice that August date.
Mm-hmm. Okay, I can leave it in the diary.
It's been in the diary for some time.
Yeah. Okay. Well, I will provisionally put 28th as being optimal that week. However, there will be the August week is still provisionally booked, and I will also endeavour to find us another date in and around early October. Yeah, I'm sure my personal life can be accommodating. Thank you. And yeah, thank you very much for that. So I think at this point, unless anybody's, oh no, we have more, crikey. Sorry, I'm all messed up now. My notes haven't printed out. Can I suggest, what do we have left? We have timetable. That's what we've got left, isn't it? Is that all we have left to do rather than have a break?
Venue.
Site inspection and miscellaneous items. My suggestion is we just plug on and get it done.
Yeah. Okay. If parties are happy with that, I can do that. I've got my notes arranged. Okay. So item 8, we have timetable for documents, written submissions, statements and precognitions. This is going to be difficult. I'm going to do this based upon the 28th, but obviously that is subject to review. So in terms of digital versus hard copies, whilst parties will likely use the online repositories to view the relevant documentation throughout this process. Apologies, Mr. Trinick.
So I probably interrupted the wrong point. It's fine to talk about the digital or otherwise, but in terms of a timetable for submission of documents, could I suggest that until we've actually firmed up the start date of the inquiry, that
we'll
maybe
just
leave that item off the agenda?
Yeah. What I can do is, in the note of the meeting, we've already discussed the dates for further written submissions, which was the 2nd of June, and the dates for the updated landscape visual impact assessment being the end of May. Aside from that, I believe everything else. We've got a couple of things like statements of agreed matters that we could maybe agree at this point as well. It just helps things moving along, I suppose, because if we do go with that August date, we need to fix some of these things for sure at this point, because things are going to be quite a tight turnaround for August. Don't worry, it's quick. It's not too much. We won't talk about the precognitions or hearing statements or anything like that. We'll just focus on the things that flow out of the note of the meeting rather than the things that lead into the inquiry sessions themselves. So in terms of the digital and hard copies, most people are going to use the digital copies. We will need some hard copies to be made available for members of the public to view in an accessible place. Does the council have any suggestions? Or can I ask that the council just puts that to us in response to the meeting if I ask a note in the note?
Yeah, if you ask us to respond in the meeting, though, I think that'll be the best way forward. We can certainly accommodate that in the usual places.
Okay. Okay, and can I confirm that a copy of the documentation will be brought to the venue for public reference during the oral sessions, either as a hard copy document or as electronic devices with the things preloaded? Would the applicant be able to provide for that when we do come to the sessions?
Yes, so that's fine. We can provide preloaded laptops.
Perfect, thank you. So as we've said, we're not going to fix any dates in terms of leading into the oral sessions because those are still subject to some movement potentially. What I will do is aim to circulate a note of this meeting, as I've said, within 7 days. Comments and feedback on it within 7 days would be ideal, in particular with regard to the proposed timetable and dates for the oral sessions. I'll also need that confirmation from parties on which topic areas they'll be submitting evidence on within 14 days of the note. No evidence needs to be submitted at that time, just confirmation of your intention to give the evidence. I will go through a couple of the quick dates. So we've said end of May for the updated cumulative impact assessment. Will then be, because that's being requested by myself, we'll then do a consultation ourselves for the 20, it'll be consulted on for the 21 days. That's the standard period. Is it 21 or 28 we normally go?
So this is a CLBIA?
Yeah.
But if it's required under Regulation 20?
We don't need to consult on it.
Don't need to advertise.
Yeah. Okay. We'll go through the process for that. Of course, all parties that are opted into the process will be given given a copy of that, and we'll come on to the email circulation shortly. So the further written submissions, I've suggested 8 weeks after the note of the meeting. which would be the 2nd of June, responses received from parties that have opted in on the LVIA, the updated LVIA would be the 16th of June. Oh no, 21 days after, because it's the end of May, so that'll be the 21st of June. I'm going to give people 3 weeks to comment. On the 16th of June, the responses to the further written submissions from other parties. So that'll be 2 weeks after the further written submissions are submitted. Other parties will have 2 weeks. I'd hope that we could have a statement of agreement 12 weeks after the meeting. So that'd be the 30th of June. Like a statement of agreed matters. Does that sound reasonable?
So do you mean all topics or on a particular topic?
Just on all topics, just so that we can narrow things down, really.
Can I suggest that actually there should be separate statement of agreed matters for landscape and visual,
Yeah,
and policy, maybe
Yeah.
other topics, but certainly those two. They're easier to circulate if it's
Yeah.
topic by topic.
no, that makes sense. That's far more efficient. Yeah, thank you very much. And then I won't touch on anything else because everything else will be based on leading into the actual oral sessions. So the dates for those will be based upon 4 weeks prior to the sessions starting for the submission of statements and whatnot. So taking all of that into account, the parties happy with the timing of those submissions we've covered today? Yeah. Okay. So I think we won't touch on closing submissions and things. We'll maybe have to just follow up on that, and I'll just include it in a separate note. The thing is, once the inquiry closes, we would normally say 2 weeks later after closing submissions of parties. 2 weeks after that would be the applicant. However, based upon what we've discussed about Eskdale Muir, there's going to be a change to that process. But that'll be articulated based on what we discussed earlier within the note of the meeting. In terms of site inspections for item 9, I do intend to carry out unaccompanied visits as soon as possible after the submission of the updated cumulative landscape visual impact assessment. Are there any issues with access or access to particular viewpoints that I should be aware of? If there are any, if you can respond when you respond to the note of the meeting, that'll be totally fine. We don't have to flag them up to me now. As part of my evidence gathering, I'll be viewing the site from the viewpoints set out within the LVIA, within the surrounding landscape where there's public access. If I feel it's important to view a site from within the curtilage of any property, I'll notify parties and I'll arrange for an accompanied visit. Following the submission of the further written submissions, and then thereafter the inquiry statements, I might carry out additional site inspections to key viewpoints if necessary. If I consider that I'd benefit from these being undertaken on an accompanied basis, again, I'll notify parties in advance to make the arrangements. And then finally, if during the oral sessions, I decide that I would benefit from additional site inspection to see something under debate, I might arrange for an inspection to take place. If it does happen, participants in that session will be invited to accompany me. Does anybody have any questions at this time about site inspections? No? Perfect. We're getting through this. So item 10, miscellaneous. The DPEA contact, as you'll no doubt already be aware, is Adrian Phillips. He's the case officer and will be your main contact during the inquiry. He'll liaise with myself as necessary, and he'll ensure documents are circulated or made available on the website as required. It'd be of great assistance if the applicant could prepare and maintain the list of core documents and submit an updated list to us when new documents are submitted. Of course, full instructions will be provided to parties as to how to upload key documents to our system when this is necessary. And in order for parties to be copied into any documents, I'd ask that when you respond to the note of the meeting, you consent to your email being included on our email circulation list between the participants that have opted in. This will mean that you're copied in when people are submitting documents or sending correspondence. And likewise, when people do submit things to us, I'd ask that all parties that are on that list are copied in. Are there any questions about the circulation of documents? No. Perfect. So the note of the meeting, as I've already said, I aim to have this done by the 7th of April, which is next Tuesday. However, given the holiday over the weekend, there might be a slight delay. And this brings us to any other relevant matters. I don't have any. So if people wish to give me a show of hands, I'll work my way around for the people that would like to raise anything. I'll start with, I've got Mr. Kerr.
Yeah, hi. Just quick thing on the actual venue itself. Do you have any shortlist, or when will those be chosen, selected? Thank you.
Yes, so we'll liaise with the council, is generally what we do, to find a suitable venue locally that can accommodate the number of people we expect will take part, and that also has we need the Wi-Fi for streaming. So we generally liaise with the council, but if anybody has any suggestions, if you could include, I'll include a question within the note of the meeting for suggestions to be made, and our support team will look into those and try and make a booking. But it will be something as close to the site and the community affected as possible.
Yeah, the rugby club has been used for previous inquiries.
Okay.
Rugby club, with the Wi-Fi there may be better than the town hall, Oik Town Hall.
Okay. Yeah, thank you. Dr. Ford?
Yes, sir. I was also going to mention the fact we haven't covered venue. For inquiries that have been in this area previously, there was a hotel in Hoyk that was used before, which I know Mr. Kirk was present at, but I can't remember its name.
Okay.
Well, the council will know it.
Yes, I was at that one, and I'm like Ford. I can't remember the name of it either. It's just as you come into Hoyk from before you hit Windsor Road.
I think so. We can.
Mansfield
It's the
Hotel.
Mansfield House. Yeah.
Yeah, I had the Mansfield in my mind, but I thought I was maybe getting confused with the rugby club because I think they play at Mansfield Park or something.
Okay, well, that's a couple of suggestions. I'll put those in the note of the meeting, and if anybody has any other suggestions at that point, when you respond to opt in, if you let us know, that'd be much appreciated. I think that's everybody whose hands are up. So thank you very much for bearing with us. We got through it faster than I thought we would. I know that there were a couple of complex bits there, and apologies that we haven't got everything nailed down and fixed at this time, but I'd hope that we will do as soon as possible. I'll get that note out next Tuesday. If the applicant can come back to me as soon as possible on those dates, that'd be much appreciated. And with that, thank you all very much for your participation, for being so well behaved and bearing with me. I look forward to seeing you all in person later in the year, and to making my journey down to the borders. Thank you.
Thank you very much.